All right, good afternoon, everyone, and thank you for joining our webinar. After a brief hiatus for the summer, we are back with our series on financial planning. Today's webinar is about estate planning, and this is divided into two parts because it's quite a complex topic, so we wanted to make sure we gave everything enough time to go through. I'm Christian, as I'm sure you all know, and I'm here with the Duca and Duca Wealth Planning Group, Derek. It looks like Eric's... Oh, just have to unmute him.
Great. Hello.
There we go.
Okay. So, how is everybody today? And let's get started.
Okay. So before we begin, our typical housekeeping for those who have been on our webinars before. We are not lawyers. The material provided today is for educational purposes only and is subject to change without notice. Every effort has been made to compile this material from reliable sources. However, no warranty can be made as to its accuracy or completeness. Before acting on any of the information, please make sure you see a professional advisor for individual financial and legal advice based on your personal situation. Derek and I, more so Derek, given his seniority, I've seen a number of wills throughout the years and dealt with quite a few situations. So while we do have a good grasp on the material being covered today, we are not actually lawyers ourselves. So today's agenda. So today we'll go through first the basics on what estate planning is. So these are just going to be fundamentally, what are we looking at or what do we mean when we talk about estate planning? And then we'll get into the key pillars, so the different pieces of an estate plan, different documents or things we'll have to do. Then we'll talk a bit about setting objectives. So how do you create goals for your estate? We'll touch on some common pitfalls to avoid. So these are situations we've seen a number of times over the years that oftentimes have unintended consequences. And finally, we'll go through a few other important considerations when putting together an estate plan. All right, Derek, why don't you kick us off with what is estate planning?
Well, estate planning very generally is management and distribution of your assets upon your death. It's also looking after who's going to be left after you, whether that's a spouse, children, perhaps a dependent relative. It's also managing your affairs when you're incapacitated. And it's about healthcare decisions during end of life or serious illness care.
So really, when it comes to end of life, serious illness care, we'll get into a few of the details on where that actually comes into play in a minute. But it's essentially, it's taking care of everything in your life when you are unable to do it yourself. So that's really what estate planning comes to, whether that's because you've passed on or simply because you're not able to make the decisions or advocate for yourself. That's what estate planning is. Now, the key pillars of estate planning. So it all starts with the will. So a will is one of the most fundamental documents of an estate plan. This governs a number of different things, which we'll get into in a moment. Then beneficiary designations are another important part of the estate planning process. So this, and once again, we'll cover it a little bit more in detail later, but this is for certain investment accounts and insurance policies, allow you to name the beneficiary of the proceeds. So those are an important part of estate planning, making sure those are correct. Looking at probate, taxes, and final expenses. So probate is an administration fee that you pay on your estate for the courts to administer the will. Final taxes, so when you pass away, what are the tax consequences? And then final expenses are funeral administration and those other expenses that are incurred at the end of our life. Next, we're looking at powers of attorney. So these can be for property or care. So these are what delegate control and decision-making authority to others on your behalf. So property would be more related to your financial and legal matters, whereas care is more for healthcare decisions. And finally, a newer one, which many people haven't heard of, is called a serious illness plan. This was developed by Dr. Highland, a critical care doctor actually from downtown Toronto, and has to deal with not quite end of life care, but if you come down with a serious illness, how do you want to be treated? What kind of interventions do you want used, and helping make those decisions? So that's just a really brief overview of the different aspects of estate planning. There's certainly a lot that goes into each of these items, but which we'll get into more in a second. So Derek, why don't you give us a brief overview of what happens when you pass away?
All right, we're going to use a simple diagram. And basically what happens when you die is the CRA, Canada Revenue Agency, basically assumes that you cashed in all of your investments and walked out of the bank or your investment place with a suitcase full of money. And that money then goes into your estate. It's treated as a separate entity. And of course, you would have to pay tax on cashing in all of your assets. You'd have to pay off any debts that you owe. You would have to pay tax on any income that you showed. And there's this thing called probate. And so whatever is left after that goes out to your beneficiaries or heirs. And there is a beneficiary designation on certain investments, but we'll talk about that later.
So this is just a really simple overview of what happens when you were passed away, how things would flow. Typically settling an estate. So from the time the money goes into estate to the time it's given to the beneficiaries is anywhere from 6 to 12 months on average. However, there's certainly ones that are much shorter or much longer, depending on the situation. But this is just a really high level overview of what the process looks like. Now, we'll go into more details on wills. So a will is a legal document. It outlines your wishes for the distribution of your assets, so how the money is spread out, and care of any dependents. So this is, as Derek mentioned, commonly your children, any minor children or adult dependents. Typically adult dependents with disabilities are covered under this as well. It starts by naming your executors. So your executors are the people who are responsible for carrying out the wishes in your will. So they're in charge of making sure what's put in the will actually happens. It's actually a significant amount of work, which most people don't realize until they've been in this situation, because it can include anything like arranging a funeral, securing and appraising any assets. So if you have to have property appraised, jewelry appraised, things like that, it's making sure you're getting it and having a professional appraisal done. Applying for probate if it's necessary. It's not always necessary. In most cases it is though. Paying any debts and taxes, accounting to the beneficiaries. So if the executor oftentimes is a beneficiary, but in either case, if they are or not, they have to make sure that they provide an accounting or a record of all the different transactions that they've executed to the beneficiaries, so everyone can see exactly what happened with the money. Distributing the assets is very important as well. They are actually responsible for giving the death certificate to the different institutions and making sure the money is spread out to the possible beneficiaries. So choosing your executors is a very important task, as it requires a number of different decisions, and it usually is best if they have some financial or legal expertise because of the amount of decisions and complexities involved. The potential consequences of either financially or legally of errors made by the executor can not only hurt the beneficiaries, but they can also hurt the estate, and the executor, it can actually be held responsible for any taxes or admin fees or penalties that they've made. You can name more than one executor, but it's typically not recommended. Before naming an executor, you should ask yourself a few different questions. And we're actually going to send out a worksheet after the presentation that will go through a few different things to think about and things to consider when naming an executor. One, do you trust them to remain objective? So family dynamics can be very challenging when settling estate. You want to make sure that they're objective to the situation and can help maintain family harmony throughout the settling of the estate. Do they have any financial or legal knowledge, or can they hire someone to help? Oftentimes with some of our clients, we'll provide them with assistance throughout the estate process if they aren't familiar with certain areas, making sure that your executor has someone like that who can support them. Are they able to help? So location, where they live, is very important. So whether it's great, you may have a very well-informed and a very bright executor, it doesn't help you as much if they live in a different country or a different province, because oftentimes a lot of travel would be required, and they would also need a lot of free time in order to take care of all of the different aspects of settling the estate. So making sure they're in the right location and have the amount of free time needed. Also their age and their health. We want to make sure if we're naming an executor that they're going to be around when it comes time to settling your estate. So another really important aspect. And then finally, is this actually something they want to do? Is it a responsibility that they want and will accept? As an executor is not obligated to carry out their duties, they can actually reject that. So you want to make sure that you've had a chance to at least ask them or speak with them prior to naming an executor, because you want to make sure that if you name them as the executor, that that's a role that they want and that they'll actually take on. Now, looking at distribution of assets, a will looks at a number of different things. So there's specific gifts or legacies that are involved. So this may be leaving money to a certain charity or a certain dollar amount, or even allocating certain personal belongings. Like maybe you have a grandfather clock that's been in the family for generations, making sure that's passed on to the right person. And then also distributing the residue of the estate, which is just what's left over after all the specific gifts and debts and taxes are paid. Looking at the certain timing and restrictions. So a will set up a number of different potential restrictions in terms of when people get the assets from the estate. For instance, if a beneficiary is a minor and under 18, or if they lack the ability to manage their finances on maturity, or you even have specific intentions on how you want the funds to be used. So you may only want, for example, funds to be used for trips or certain gifts or medical expenses, or however you would like to, whatever rules and restrictions you'd like to set aside, that would be all allocated in the will. A great example of this is if a parent left a large inheritance to their children, and they wanted their children to feel like they were still around. So what this parent can do is put restrictions in place, like I mentioned earlier, so that the money that's left to their children can only be used for medical expenses, grandchildren gifts, trips, and things like that, so that it feels like that parent is still there. That would be a great example of some restrictions left to those assets. And finally, it also governs what happens to a beneficiary if they predecease you, or what happens to their share. So oftentimes, if you name a beneficiary and they're no longer around when you pass away, what happens to their share of the estate? Does it go to their kids? Does it go to the other beneficiaries? There's a few different ways how they can be divided, and that would be set aside, or that those terms would be set aside in the will. Finally, looking at care of dependents. So similar to choosing an executor, you want to think carefully about who you put in charge of the dependents. If the person is not a beneficiary of your will, or they're not in your will already, your will would allocate a certain amount of money towards the care of those dependents, or you typically want to allocate a certain amount of assets to help them cover the additional costs. That would all be determined in your will. Derek, I know that was a bit long-winded, but anything else to add on wills?
Well, that was very good, Christian. I'll just sum it up with a couple of short phrases. First is that this is really you standing with one foot in the grave and giving out your last instructions to your heirs. So make sure that it's what you want to have happen. And secondly, the executor, as Christian mentioned, it's a very important role. It's not rocket science, but it's very time consuming and administrative heavy. So carefully select somebody for this role, because there's a lot of administrative work to go through. And again, most of it's quite simple, but it takes time. Excellent.
All right, thanks, Derek. So next, Derek's just going to go into beneficiary designations.
So we talked briefly about beneficiary designations. And there are certain investments such as registered plans, RRSPs, RIFs, tax-free savings accounts, life insurance policies, segregated funds that can name a beneficiary. And what happens when you name a beneficiary is it bypasses the estate. So if we go back to our simple example, what happens is the money that has beneficiary designation bypasses the estate, bypasses probate, and goes directly to the beneficiary. So your actual estate is much, much smaller. Now, it's a very quick distribution, bypasses the probate, which is great, but, and it's a big but, it does not bypass income tax, and the estate still owes the debts. So one thing that you need to be aware of is that a beneficiary designation usually will override whatever is in the will. So, and anytime you change, like if you convert an RSP to a RIF, that's now a new beneficiary designation, which is the most recent. Or if you transfer from one institution to another institution, that now updates the beneficiary designation. So I'm going to let Christian carry on and talk a little bit about the tax problem.
Thank you, Derek. And Derek made a great point about making sure your beneficiary designations match your will. Both of them are responsible for distributing the assets, but you want to make sure that they match, because when they don't match, there are some certain rules that govern how things will be distributed and how which one the courts will follow. But anytime they don't match, it's just opening up the will to, the potential for the will to be challenged and having the courts involved, which nobody wants. And Derek mentioned a great point, which we always try to reinforce as much as possible, is that bypassing the estate and bypassing probate does not mean avoid tax. And as our good friend Benjamin Franklin once said, nothing in the world can be certain except death and taxes. And so we certainly want to make sure that everyone knows that it does not bypass taxes. So now, looking at the different responsibilities and taxes. So we talked about probate earlier, this is the first one. So in Ontario, we don't have an estate tax, but the three main costs to you would be probate, like we said, final income taxes, and final expenses. So probate is just a formal court procedure to approve the will as the last valid will that you've had. So the courts want to make sure that the will that they're being presented is in fact the most recent will, and there are not any other wills kicking around that are newer and reflect updated wishes. So everyone will typically update their wills over the course of their life, and the courts put together this probate process to make sure that they have the most recent one. Now, for estates, the cost of probate is fairly nominal. So for an estate under $50,000, it's $250 flat fee. Estates over $50,000, it's $250 plus 1.5% of the value in excess of $50,000. So for example, if the estate was worth $100,000, the probate fee would be $1,000. So you would have $250 on the first $50,000, and then 1.5% on the second $50,000, which would give us $1,000. It's really important to come up with a plan to reduce probate expenses, but at the same time, there are some strategies that can expose you to a lot more risk in order to avoid what's typically a nuisance fee. And the probates it does work out to be a fair bit of a fee from a dollar perspective, but in the grand scheme of things, the risks that sometimes you can expose yourself to with certain strategies to avoid probate are often not worth the money you are essentially saving. And we'll go through some examples later. Now, looking at taxes, final income taxes are typically the largest expense to your estate. So these are from your final tax return for the year that you passed away. The reason this is the largest expense, and Derek mentioned earlier, is the CRA treats your assets as if you had sold everything and walked out with a briefcase full of cash the day you die. There are some exceptions, but in the interest of time, we'll look at those in part 2 of our series. So for example, if you had a $500,000 RSP, your final tax return would show $500,000 of RSP income, and you'd owe about $230,000 in taxes. So it's a pretty significant expense that can be incurred. And once again, there's a number of ways to avoid that, which we'll get into later, but that's essentially the gist of what final income taxes look like. And then lastly, we have final expenses, and these are what we mentioned earlier. So funeral, burial, filing expenses for filing the tax returns, legal and admin fees, settling the estate, and appraisal fees, and those kind of little expenses here and there that are incurred in the year of death to make sure that the estate is settled. Derek, anything to add on probate, taxes, and final expenses?
The only thing I would add is that when we work with you, we're doing the best we can to minimize your income taxes on death and minimize probate as well by advanced planning. And so that's something that happens on a year-by-year basis. And hopefully people live long enough to end up owing very little income tax and very little probate.
Mm-hmm. So Derek, why don't you take us through a brief little example of how probate and taxes work with our friends Jane and Billy.
Okay. So Jane is a widow and has only one son, Billy. Now she's got $100,000 in her bank and $250,000 in her RRSP. She doesn't own a home, so that's her entire estate, if you want to call it that. She passes away, and she has named Billy as the beneficiary on her RRSP. So $250,000 goes directly to Billy. The $100,000 in her bank account goes into the estate. So there's going to be, as Christian had given us in the example before, $1,000 worth of probate, which needs to get paid out of the estate. Now, even though the estate is technically only worth $100,000, CRA says, oh, but you cashed in a $250,000 RSP, you owe us a whack of taxes, which is $96,000. So that leaves only $3,000 in the estate. So Billy gets that as well because he's the sole beneficiary. So we have saved we've saved a few $1,000s in probate. We still had to pay the tax, and Billy has only $3,000 left to bury his poor mother. So hopefully he's got a little extra cash from that RSP that he has. So he does have the money, but it's not in the estate. And so this is where, if we get into a little more complex situation where there were some other debts being owed or whatever, now you can see where things get a little bit more difficult when you have beneficiaries of the majority of the assets, but the estate ends up owing a whole bunch of money. Did I miss anything, Christian?
No, that's exactly it. As Derek mentioned, the RSP beneficiary would get paid out right away. So Billy would get that $250,000 in his hands almost immediately as soon as he submits a death certificate. But the actual settling of the estate, paying taxes, paying probate would take anywhere between 6 to 12 months or potentially longer. In situations like this, it's typically a pretty quick process. But if there's multiple beneficiaries and some of them can potentially challenge the will, which we've seen a number of times where they don't necessarily agree with what's being done, it can drag these processes on for a very long time. So that's another reason why it's very important to go through your will, go through your beneficiaries, make sure they match and have a really good understanding of what you want to accomplish. Now, moving on to powers of attorney. So these are the documents, they're known as powers of attorney in Ontario. But other provinces have different names for these documents. Some of them would call a power of attorney for healthcare as a healthcare directive. There's a number of different names for these, but in Ontario, they're called powers of attorney. So the first one is a power of attorney for property. So this manages your financial affairs. And there's a few different kinds of powers of attorney and a few different forms they come in. So a power of attorney manages any of your financial and legal affairs, and they can essentially do anything that you could do with two exceptions. They can't update your will or can't change your will, and they can't update your beneficiaries. So besides that, they can do pretty much anything. And you can actually create limited powers of attorney if you want to restrict those powers even further. So for certain situations, you can actually create a limited power of attorney that says this person can act on my behalf under these specific circumstances or in these specific situations, but nothing else, just that. So those are what we call a limiting power of attorney. But looking at the three different forms of power of attorney here, the first is called a continuing power of attorney. So this comes into effect and as soon as it's signed. So it's also known as a durable power of attorney. There's a number of different terms for these depending on the province. But in Ontario, it's typically called a continuing power of attorney. So as soon as this document is signed and drafted by the lawyer, that this document can be used and it continues to be in effect. This is where the continuing portion comes into play when you become mentally incapacitated, or if you become mentally incapacitated and can't make decisions for yourself. So that's why it's called a continuing. It comes into effect as soon as it's signed and it continues even if you become incapacitated. Whereas a non-continuing power of attorney, or also known as a general power of attorney, would come into effect once it's signed, but it can't be used if you become mentally incapacitated. So if you can't make decisions for yourself, a non-continuing power of attorney is no longer valid. It doesn't continue through incapacity. So this would typically be used in a situation where if you would spend long periods of time out of the country and need someone helping to manage your affairs, but they're not necessarily the person you would want to make decisions for you if you weren't around. So you'd use a non-continuing power of attorney. And then finally, a springing power of attorney. So this, like it says, it springs into action when a certain condition is met. So typically this is what happens when you become incapacitated is you would have a springing power of attorney that says, when I can no longer make decisions for myself, and this has been certified by a medical expert, this document is now valid. So it'll be signed right away, but it's not valid until the conditions are met or the springing conditions are met, and that's when it comes into play. Derek, any addition on financial POAs for property before I go into personal care?
The only thing is that, as you mentioned, it's very important to know that people can actually use that in most cases immediately in a continuing power of attorney, which is what the most common form is. And so we are seeing an increase, not personally, but across the country, abuse of POA in clients' situations. So it's just something to be very careful of.
What we would typically recommend or tell clients is that if they do have a continuing power of attorney, that they don't distribute copies. They either keep them at their lawyer's office, or if they have a safe place at home, somewhere you would typically want fireproof or waterproof so that the documents can't be damaged until such a time that they're needed. And that way it just avoids the situation. But another great point, Derek, that your comments made me think of with the springing power of attorney. Oftentimes it's important to think about when you want these documents to come into effect, because the springing power of attorneys, one of the downsides with waiting until you're incapacitated for the document to take effect is that it can be a very stressful and oftentimes difficult process because it requires you to essentially declare or admit that you're unable to make decisions for yourself, and you would have to have a doctor sign off on this, which we've seen with a number of clients is very difficult. It's very challenging, and it's hard emotionally to come to terms with the fact that you can't manage your own affairs, which is why sometimes with those springing powers of attorney, if a parent wants their children to help out but can still make decisions on their own, they can't use that springing power of attorney. So they'd have to draft a new one, or just wait until they are no longer able to. So that's a few situations we've seen with the springing power of attorney. Typically, some lawyers will recommend a springing power of attorney if they're worried about that sort of abuse that Derek mentioned. They're worried about someone using that document in a purpose it wasn't intended to, or before the parents are wanting it to come to effect. That's why they'll put that restriction in, but it's not always the case. Now, the next type of power of attorney is for personal care. So as we mentioned before, this is related to healthcare decisions. So this is for end of life care, typically, when if you're not able to make a decision for yourself, this person will be able to work with your doctor and be able to advocate on your behalf for doctors. It typically does provide instructions for that person. So if you've reached the end of your life and you're no longer responsive, it'll typically outline how you want to be cared for. So whether that's extraordinary efforts like resuscitation, life support, and different machines like that, or if you want a do not resuscitate or a DNR, whereas if your heart stops naturally, you don't want it to be restarted by any artificial means, that will typically be outlined in a power of attorney for care. Derek, anything to add on power of attorney for healthcare?
No, that's an important thing to have as well.
All right. So finally, you can name more than one power of attorney. You can have them named as joint or joint and severally. There's a few different reasons why you'd use one or the other. So a joint power of attorney, if you name 2 or 3, you can potentially name as many as you'd like. But a joint power of attorney means that anyone listed as your power of attorney has to sign off and agree on the decision. So it has to be unanimous. Whereas joint and severally means they can act together or individually. Why these distinctions are important, and what we often tell clients, is that for financial affairs, typically it's best if their powers of attorney are joint, because that way everyone is kept in the loop. Whereas joint and severally is typically recommended for personal care, because if there was a healthcare emergency, you'd want someone to be able to act right away and not have to wait for 2 or 3 or potentially more people to respond in order to make a critical care decision. So that's typically where those 2 different types of joint powers of attorney are used. And it's important that you distinguish in your power of attorney how you want things to be handled. So once again, if, for instance, you get into a car accident in the middle of the night and you've got one power of attorney locally and one power of attorney in BC, it may be difficult to get a hold of both of them. So you want to make sure that you can get a hold of one and they can make the decision and not have to wait for the other. It's just an example of when those situations would come up. Derek, anything to add on joint powers of attorney?
Yeah, the only thing I'll add is that having multiple powers of attorney is fine, but it's different than having a single power of attorney with 1 or 2 or 3 alternates. So joint means that they either have to act all together, or in the case of severally, they can act independently. Alternates are simply, you've got one power of attorney, and for married couples, it's usually their spouse first, and then they name alternates, perhaps one of their children or a friend, something like that. So you should always have at least 1 or 2 alternates.
A great point.
And the last thing I'll put in this is really the will and the 2 powers of attorney form the core of your estate planning documents. That tells the will is what tells people how you want things done after you're passed away. And the powers of attorney are helping people look after you while you're still alive.
Great points, Derek. So next, Derek's going to go into a little bit about advanced serious illness planning. So this is a newer area, as we mentioned. It's not as widely adopted, and Derek's going to go through a bit of the differences between what a power of attorney would cover and what advanced serious illness planning covers.
Excellent. It is very new, and so I'm just a beginner at this as well. So the end of life care, which is primarily dealt with through the power of attorney, again, do they resuscitate you and so on, it's when you're certain that there's no chance that you're going to survive. Whereas advanced serious illness planning is saying, well, I might get sick I might lead to death, but on the other hand, I could recover. So the end of life care is basically you make the decision in advance. Yes, resuscitate me. No, don't. Whereas the advanced serious illness planning is preparing in advance to make decisions. Who do you want involved in that? And who do you collaborate with? So the end of life care is literally put into place in your power of attorney for care without the input of your doctor or health professional or whatever, because it's typically done when you're still healthy. The advanced serious illness planning sets up a plan for who should you consult with and who should you collaborate with when you get into this situation or if you get into that situation. So again, it's something new and looking at, because as doctors and healthcare continues to make advances, what might be considered an end of life situation right now, 5 years from now might not be. So it's important to start to take a look into this.
Mhm. And those are some great points, Derek. The advanced serious illness planning is very new, but it's helping guide the person making those decisions for you and your doctors on how you want to be treated. So if there's a chance of recovery, are you wanting to go into an ICU or have extensive CPR used? What kind of machines or what kind of treatment are you willing to undergo if it means there's a chance of survival? So that's what the advanced serious illness planning is. It isn't making a decision. It provides a framework that your doctor will understand in terms of how you want to be cared for so that they can make the decision that's best for you. Because really, in reality, what happened, and COVID was a great example, is a lot of doctors made decisions because they weren't able to understand exactly how that patient wanted to be treated. And oftentimes it can result in either a patient being kept alive in a state that they didn't want to be kept alive in, or the doctor not going through the efforts that person would have wanted in order to keep them alive when there was a chance of survival. So it's an advanced serious illness plan helps to deal with those situations where there is uncertainty and they aren't sure what's going to happen. So what kind of measures are you willing to undergo in order to try and survive? So that's what the advanced serious illness planning is. And thank you for those who have submitted questions. We will get to it in the Q&A at the end, as we discussed earlier. But thank you for those who have submitted questions in the chat. All right, so now looking at the principles of estate planning. So this is, what do we look at, or what are we thinking about when we put together an estate plan, and specifically looking at our will? So the first thing we want to do is we want to make sure we're meeting your own needs first. So as much as we talk about giving to family and giving to others and supporting others, the first thing with estate plan is making sure you're taken care of. Because if you're not taking care of yourself, that means that others will eventually have to take care of you. So we want to make sure that your own needs are met before looking at, okay, what can I give to others? So next, we want to make sure we're protecting your estate from erosion, from taxes and final expenses. So Derek mentioned this earlier. So taxes, probate, what can we do to reduce those expenses to make sure we have as much of what you've worked hard to earn throughout your life left to give to those that you want to give to? Next is judgment proofing your estate to the maximum extent possible. What this means is we want to make sure that there's no opportunity or possibility of conflict or arguments in terms of interpreting what your will means. So we want to make sure we've checked every base and covered every base and checked every box possible so that there's no misinterpretations of your will or your wishes. We want to make sure that there's no chance for it to be argued or challenged in the courts. And finally, we want to make sure we distribute your estate in an orderly fashion. So we want to make sure everything is done in a timely manner and there's no major hiccups or things holding back the distribution of your estate. We want to make sure it flows smoothly. And to paraphrase a quote we once heard is, nothing creates more resentment in a family than a messy estate. So it's really important that this process goes as smoothly and as orderly as possible with the least amount of conflict, because oftentimes money can do funny things to people. And that's, we know with a lot of people, that's not what they want their estates to be. They want their estates to give gifts and help lift people up and not create conflict and disharmony. Derek, anything to add on the principles before we go into creating your objectives?
Oh, that's a great summary. And basically, what we have to look at is two things. One, the majority of us will live to a ripe old age and will die slowly. And we can do a lot of these things and give away the grandfather clock and those things before we die. But we need to be prepared that we get hit by that proverbial bus tomorrow. And what would happen then? And that's often why people put off estate planning, is because they think, well, even if I get sick, I'll have 6 months or a year to organize things. That's not always the case. So our job is to help motivate you to get things in order now, and then continue to gradually work through these things so that by the time you do pass away, it becomes very simple and is easy to take care of. So that moves us right into setting your estate objectives. And so really, what we'd ask people to do is, in simple terms, if you were to die today, what would you like to do with your estate? Who gets it? How much? When do they get it? Those kind of things. Is there a charity that you're particularly fond of? Do you have a disabled niece or nephew or relative? Anything like that. So what would cause you to change that distribution, and how would it change? So if you're a married couple, would that change if one of you were to pass away? Now, typically not, except that now we're finding roughly 50% of the population are remarried and have blended families, which can create a whole different ball of wax and lots of confusion. So we'll get into a little bit of that later. If one of your beneficiaries died, one of your children predeceased you, heaven forbid, but that does happen, how's that going to change things? What about what you'd like the funds used for? Do you want to pass on values? That's also part of your legacy. It's not just money. It's what you stand for, what you want your family or your beneficiaries to stand for. And do you have any concerns about your beneficiaries' ability to manage an inheritance? Either because they're a spendthrift, because they're addicted to drugs, because they've got mental or physical health challenges. There's a lot of different situations that could come up where you might have concerns about that. So those are the basic sort of core principles of setting up your will and how you want your estate distributed.
Some great points there. You covered everything very well. And these questions oftentimes take some time to think about. And if you're in a relationship, it's something you certainly want to discuss and not rush to a decision, because you want to make sure you're really thinking through these decisions. Things like the passing on values. Oftentimes people have worked very hard to earn, to create the funds that are going to be in their estate, and they want to pass on the values that they lived by that help them create this wealth on to the next generation. Because what unfortunately happens is typically a large inheritance will last 3 generations. The first generation makes it, the second generation maintains it, and the third generation blows it. And that's very common actually across the world, that occurrence. So we want to make sure that there's certain values, hard work, that you lived by, that you can pass those values on and have those discussions with your future generations so they understand, this is how we accumulated this wealth, and this is how we'd like to see it used. And then Derek mentions a lot about concerns about beneficiaries' ability to manage an inheritance. This may not be a personal slight. It may just be that they're not old enough. And oftentimes we've seen that, and we've seen situations where a student in university inherits a lump sum of money, And before you know it, that lump sum of money is gone because they've spent it out having fun with their friends, buying fancy things, and just because they don't have the emotional or mental maturity to manage that sum of money. So those are situations where you would want to potentially put some restrictions in to make sure that the money is there when they're mature enough to understand how to use and manage it. So now, looking at some common pitfalls. So these are things we see and we've kind of touched on throughout the presentation, but things we've seen in the past that have some unintended consequences. So the first is using joint ownership to avoid probate. So this typically can look at a house or a cottage or even bank accounts where a parent has said, I'm going to put my son or daughter as a co-owner on this property or co-owner on this bank account so that it bypasses the estate and it flows right to them when we pass away and we don't have to worry about probate. The challenge with that is, for example, if you were to put your bank, say you have $100,000 in your bank account, looking at Jane earlier, and she puts Billy on as a joint owner in her bank account. Well, now all of a sudden, if Billy was married and say Billy gets into some financial troubles or ends up being divorced, well, now that bank account that's joint ownership is now exposed to any of Billy's creditors. So if Billy gets divorced, potentially half that bank account goes to Billy's ex-wife. Or if Billy was a joint owner on the house, half of the value of that house would have to be paid out to Billy's wife or Billy's ex-wife. So those are situations with joint ownership. It exposes that asset is now technically their property too. So any situations that affect them, that property can be used to pay off creditors or pay off a separation agreement. So that's one issue that we've seen with joint ownership, especially. Looking at no tie-breaking procedures. So this is either with executors in a will or powers of attorney. If they're joint, that's where we talked about joint and joint several powers of attorney, but more specifically looking at executors. So if two children are co-executors, potentially we've seen one example where there was a very simple estate with a large sum of money, but the brothers didn't get along, and it's taken over 4 years for the estate to settle. And the lawyer's fees throughout that process have significantly eroded the value because they aren't able to agree on anything, and everything goes through the lawyers. So that's a situation we've seen in the past where it's been very challenging. There was no tie-breaking procedure put in place. And a tie-breaking procedure can be as simple as, flip a coin, heads gets the decision. Or it can be something like involving a third person who's maybe not an executor, but they get the deciding vote if there's an impasse. And so making sure there's this goes back to the judgment proofing or reducing the conflict. If there's a tie-breaking procedure, then you don't have to involve the courts. It's a very easy mechanism. We talked about this earlier already, joint and several POAs. So if there's 3 children hypothetically in a situation where they're all joint and several POAs and there's an accident and you can only get a hold of one, that one power of attorney can make the decision for you without having to wait or consult the other 2 and agree on something. So they can make that decision right away. On the financial side of it, an example we've seen and read about is if there was 3 children were joint and several powers of attorney for property, within a span of a few hours, all 3 of them called their parents' advisor and gave completely separate instructions for the assets that that advisor managed. So in that situation, which you can see that each of them can act independently, but they're all giving different instructions. So that's a great example of why with powers of attorney, we typically recommend joint so that you don't get into those situations. Using dollars or versus percentages for specific gifts and legacies. So this is a great example where, depending on your situation, you want to make sure that there's enough assets in your estate for those specific gifts, because those specific gifts get paid out before the residue or what's left gets distributed. So hypothetically, you could say, I want to give $100,000 to Sick Kids Hospital. Well, if at the end of your life, you only have $100,000 left in your estate, that gets paid out before any of your beneficiaries would get the residue of your estate. So you may not want everything going towards that specific gift. But if you use a dollar amount, that dollar amount gets paid first. Whereas if it's a percentage, everyone still gets a little bit. Looking at beneficiary designations, we talked about beneficiaries not matching the will. That's a very common example where we've seen in blended families where a parent has changed their will but didn't update their beneficiaries. So the beneficiary, the money in the beneficiary account got paid out right away to the spouse in this situation. It was a second marriage, and the child was actually in the will supposed to get more of those assets, but because the beneficiary assets don't go through the will, that child was then disinherited because all the money that was supposed to go through to them under the will got paid out to somebody else in a beneficiary designation, and that person didn't get anything. Derek, anything to add on these examples that we touched on?
No, those are great examples and very, very common. We've experienced all of these in our own client base over the years. And we see it quite often in wills that we look at. So there's a few other important considerations. So one of the things that's becoming more and more common, digital assets or accounts. A lot of these are just social media, Facebook, LinkedIn, Instagram, whatever. But some of those are financial accounts. Some people might be investing in Bitcoin or things like that. You need to have notations and records of that so people can get to that. You've probably known this as well. I've seen on LinkedIn a number of times friends or clients that have passed away, and all of a sudden it pops up and says, oh, wish them a happy 10th anniversary at their workplace. Obviously, the executor didn't know what their passwords were or had no way of contacting all the different things. Having clear instructions for your heirs and executors on how to distribute personal assets, that grandfather clock that Christian mentioned, and other things. Oftentimes we find that some of the biggest causes of, how shall we call it, disagreements within family are over some of the sentimental items, not so much the money. And so it's very important that you make a list of some sort or give some kind of instruction to your executors. Leaving key contact information. The most humorous one that I'll call about is one client when we talked about, so what would you do, like if you were to pass away, like in the very near future, what would you want? So, well, I would give my husband a key to the safety deposit box. I'd give him your phone number, and I'd give him the names of and phone numbers of 2 or 3 women that I think would take good care of my children because he wouldn't make it on his own. So there are different key contact informations that you want to leave with people. In home insurance, if you have pre-purchased funeral packages, all those kind of things. And as you go through life, simplify your situation as much as possible. There's really no need for dealing with 5 different banks, 3 different financial advisors, all these sort of things. The more you can simplify your situation and have it documented, the easier it is for both you and your heirs or powers of attorney to deal with situations when the time arises. Anything else, Christian?
Derek, you covered everything great. One comment on the last point, simplifying your situation. We've seen this a number of times. It's not only financial institutions, bank accounts, things like that, but also credit cards, subscriptions, memberships. Because we've seen a number of times, that's what oftentimes is a lot of the legwork when it comes to being an executor or power of attorney, is though all of those little things, your Costco membership, and these things. So simplifying those can be immensely helpful. And when it comes to looking at the different institutions, with the powers of attorney, every institution would have to register that power of attorney in order for it to be used. So they would have to submit it, it'd have to go through an approval process. So that can be very time consuming if you have to go to 4, 5, 6 different institutions, submit the power of attorney, and go through their oftentimes separate process for approving that power of attorney before you can help them out with anything. So simplifying down to, we typically recommend as few institutions as possible. Not only helps you out, but also helps your heirs out. So that concludes our presentation. It's a little bit longer this time, but we hope you got a lot of great content out of that. Our next webinar will go through more in-depth estate planning using things like trusts. We talked about how some assets can be passed without paying tax. We'll go into a little details on that. Some examples of how to use insurance in estate planning. And so that's something we'll go into a little more depth of the advanced estate planning topics in our next webinar. In terms of questions that were submitted, there was a few here. I'll take the first one here. So it says, what's the best way to give my cottage to my kids without them fighting over it? This is a good one that we see actually quite often. To paraphrase an estate planning lawyer, sell it or burn it for the insurance money. We're joking, obviously, for the second part, but that's really the cottages. Family cottages are often one of the biggest points of contention in an estate plan because everyone wants access to it, but not everyone wants to pay to maintain it, and not everyone agrees with how it's going to be maintained. Sometimes you can come to an equitable solution where one beneficiary gets the cottage and the others are either paid out, or there's an equalization some sort, either through financial assets or otherwise. But shared cottages, in our experience and from our colleagues, those are oftentimes one of the most difficult situations. Regardless of how you structure it, some people have tried using trusts, some people have tried using corporations, and there's a number of different pitfalls that come with that. We'll go into cottages specifically more in our next webinar. That's one of the examples we used because there's a number of different ways it can be handled. It can be handled with some pros and cons and some suggestions. So we'll touch on that more, but oftentimes it's best if you can't agree for one of them to take it, it's best to either just sell it and split the proceeds, or find some other solution that doesn't involve a shared cottage. All right, Derek. Derek, there was a question that says, what happens if I die without a will? You want to go through that briefly?
Very briefly, literally the government steps in. It has a list of, goes to spouse. No spouse goes to parents. No parents goes to children. No children goes to siblings. And guess who's at the bottom of the list? The government. So it also takes over if you have children and you don't have a will with any caretakers named for the children. So that's what scared me into getting my first will. When I learned that the government would not only look after my money, but would look after my kids, the thought of them acting as parent figures frightened me so badly, I immediately went out and got my first will. And I've updated it a couple of times since then as situations have changed.
Mm-hmm. And that's a great example. That process is called intestacy. I believe I'm pronouncing that right, intestacy. And we'll actually cover that in our next webinar in more details. But as Derek mentions, there is a preferred, what's known as a preferred share, and then a division. And it all is based on what your family situation is. So if you have a spouse and dependent children, or just a spouse, or no dependents, the government has a formula essentially that says, okay, this amount, for example, with a spouse, this amount goes to your spouse, and then the remainder is divided between your spouse and children. And they have, depending on your situation, they have a number of different formulas, and they have a whole chart on how it's distributed, which we'll go into in more depth next time. So what happens if an executor predeceases you, or your executors predecease you? So if you don't have alternative executors, you would have to, once again, the government and the courts get involved, and the courts would essentially appoint an executor for you based on the family relationships. Typically is how it would be done. So they would appoint it for you. So in most situations, when it comes to an estate planning, if something's not already done or a decision's not made in advance, that's where the government and the courts step in, which is why we do our best to try and avoid that as much as possible, because the second the courts step in, that's when things tend to get expensive. Derek, anything to add on that?
And often it'll be, what do you call it, a professional trust company or something like that. So there will be fairly significant executor fees to be paid out of that, which reduces the ultimate estate to your heirs. So in wrapping up for today, to put it in building terms, we've basically laid the foundation and we've framed the walls for estate planning. Next session, we'll look at putting in some of the extras, you know, how many washrooms, how many light fixtures, what kind of light fixtures, all those kind of things. But this covers the core of what estate planning is all about. And as Christian said, we'll get into some specific details like cottages, like if you own a business, what if it's a blended family, all these different kind of things, which add significant complexities. So anything else to add, Christian?
That's really everything. So after this, when we send out the link to the recording, we're also going to send a worksheet that'll go through a few of the topics we've discussed today with some questions to think about and some areas to fill out your responses. This will just serve as a nice guide to help you organize your thoughts regarding estate planning. We'll also send out a link to the Advanced Serious Illness Planning website. It's called Planswell. Just a disclosure, we have no affiliation with them. This is just a very useful tool that's becoming popular and we thought was a very important part of estate planning. So we'll send a link out to that website. It gives you a nice informational and educational experience in terms of what serious illness planning is. And it'll actually help you generate a letter that you can have signed and given to whoever would make your decisions for you, that they can then present to the doctor in the event that you become seriously ill and it's needed. So it's a great resource out there. So we'll send a link out to that as well after the webinar. All right. Well, thank you everyone for joining us. We appreciate the time and we're looking forward to seeing you at our next webinar.
Have yourself a great afternoon.
Take care.